All right, let's jump right into a really fascinating historical paradox. For this explainer, we're going straight to the source material from the 1930s and 40s to unpack a very specific, highly charged political narrative. We're going to look at how Adolf Hitler and the Nazi regime painted this picture of English law and the British Empire, and then we're going to compare that propaganda directly against the actual, documented historical precedents. The core of what we're looking at today comes down to a really stark contrast. See, Hitler portrayed English law as this brutal system of conquest, exploitation, and raw imperial power. But in reality, its constitutional tradition formally grounded authority in inherited legal restraints, due process, property rights, and strict limits on the ruler. So it's essentially a massive clash between a totalitarian projection and constitutional reality. So, to really understand how the Nazi regime viewed global power, we first have to ask ourselves, was their framing of English expansion actually accurate, or was it purely just a projection of their own twisted worldview? Nazi propaganda consistently praised British ruthlessness, and they literally pointed to it as justification for their own actions across Europe. But to get to the truth, we need to separate that rhetoric from the actual legal foundation. Did the English system really just operate on the unchecked will of whoever was the strongest, or were there real underlying structural restraints? Okay, here's our roadmap for today's explainer. 1. Hitler's view of England. 2. The propaganda of exploitation. 3. Roots of legal restraint. 4. Covenants and Magna Carta. 5. Property and limited power. And finally, 6. Dictator versus rule of law. Starting off with Section 1. Hitler's view of England. Admiration and ambition. Now, it's pretty wild to think about, but Hitler actually harbored this deeply twisted admiration for what he perceived as ruthless colonial domination. In his writings, like his Zweites Buch, and in recorded conversations from around 1942, he kept citing British rule in India as the ultimate model for how the Germans were going to rule Eastern Europe. He literally called Eastern Europe Germany's India. He didn't see the nuances of English law at all. He only saw imperial might, which he viewed as proof of a superior race conquering inferior ones. To Hitler, the British Empire wasn't some complex legal structure. It was just a blueprint for territorial supremacy that he was eager to replicate. And then you have Joseph Goebbels pushing the second part of this propaganda machine. In his speeches, like the big one he gave for Hitler's birthday in 1940, Goebbels went out of his way to deliberately strip away any notion of English legal morality. He told the German public that the British Empire was built on nothing but, quote, war, oppression, concentration camps, starvation, and blood. He argued that any time the English talked about fair play or justice, it was entirely hypocritical. He actually called it mimicry, just a mask they wore to hide their raw exploitation of the world. Moving right along to Section 2, the propaganda of exploitation. So here's the crucial thing about the Nazi framework. They willfully ignored centuries of actual constitutional limits. In their minds, authority was absolute, period. It was just the unbridled will of the strongest actor in the room. Our sources show that totalitarian systems like this reduce human beings to mere abstractions of will and desire, where absolutely no higher norm restricts power. The Nazi state claimed civil sovereignty meant total territorial supremacy, completely devoid of any moral accountability whatsoever. And they projected this exact same philosophy onto England, just assuming the British ruled exactly how the Nazis intended to rule, by brute force alone. Which brings us to Section 3, Roots of Legal Restraint. Look at this direct contrast. It's honestly striking. On one hand, you have Goebbels screaming that English power is just unchecked violence. But then, if you look at the actual historical precedent, you find Henry de Bracton, a 13th century English jurist. In his massive treatise on the common law, Bracton explicitly wrote that the king himself ought not to be under man, but under God and under the law, because the law makes the king. He literally argued that there is no king where mere will wields dominion. So this wasn't just some propaganda mask. This was the foundational philosophy of English jurisprudence firmly restraining the sovereign. And this wasn't an overnight thing, right? If we track this chronologically, we see a centuries-long evolution meticulously designed to lock in limits on rulers. Back in 1215, the Magna Carta instituted the law of the land principle, protecting people against arbitrary imprisonment. Fast forward to 1584, Haydn's case formalized exactly how laws should be interpreted to prevent mischief. And then the 1689 English Bill of Rights made it flat-out illegal for the monarch to suspend laws without Parliament's consent. We are seeing a progressive locking in of legal boundaries here, which is the exact opposite of absolute unbridled will. Section 4. Covenants and Magna Carta. The historical sources tell us that figures like Stephen Langton, who actually helped draft the Magna Carta, viewed it almost like a biblical covenant. It was a binding agreement that placed real moral and legal obligations on the king. And that tradition gave birth to what we now call internal constraints upon sovereign power. We're talking due process, equal protection, and eventually freedom of speech and protection against unreasonable searches. These specific guarantees literally embedded moral accountability into the system itself. It made sure that authority was treated as a public trust, not just some arbitrary violent force. All of this culminates in a concept you've probably heard a million times: the rule of law. As scholars like A.V. Dicey pointed out, it's the constitutional principle that absolutely no person, not even the sovereign monarch, is above legal accountability. And this definition completely shatters that Nazi assumption that English power was just the unchecked will of a ruling clique. In the English tradition, if the ruler steps outside the law, their actions become legally invalid. The law is king, not the man. Section 5. Property and limited power. When we look at original texts from philosophers like John Locke, we can really trace how English constitutionalism tied supreme power directly to preserving the common good rather than just exploiting people. Locke made the case that government is naturally and necessarily limited by the very reasons it was established in the first place. Think about it. A ruler can't just destroy the common good because preserving that common good is literally the only reason they have authority to begin with. Let's actually break Locke's principle down a bit more because it's a real game changer. He explicitly stated that the supreme power cannot arbitrarily take any man's property without his consent. And when he says property, he means life, liberty, and estate. People form societies specifically to protect those things. I mean, imagine if a government could just seize your assets on a whim. It would defeat the whole purpose of having a government. This concept firmly established the government as a constitutional steward. It created a massive structural barrier against the exact type of totalitarian, confiscatory state that Hitler was building over in Germany. And that brings us to our final section, number 6, dictator versus rule of law. If you lay these two models side by side, it is a night and day difference. The clash is absolute. Over in the Nazi totalitarian model, authority comes strictly from unchecked will and raw force. The state owns everything, and your rights only exist if the dictator says they do. But in the English constitutional tradition, authority comes from inherited legal restraint, the parliamentary process, and due process. The sovereign is bound by the law, and property is an unalienable right that's protected from arbitrary seizure. It is an architecture of inherited legal restraints directly opposing a system of raw imperial conquest. Ultimately, what you should take away from this explainer is how the very definition of authority dictates the destiny of millions of people. Hitler projected his own dark ambitions onto English history, seeing nothing but violent conquest. But the reality of the English legal tradition was a centuries-long struggle to formally ground authority in legal restraints, property rights, and strict limits on the ruler. So I'll leave you with this to think about. When we look at governments today, does their foundational authority rest on absolute unchecked will, or is it a restrained public trust? Because the answer to that question changes absolutely everything. Thanks for exploring this with me.